everyone. Welcome to the Disability Law Center's webinar on healthcare decision-making for older adults. My name is Melissa Charles-Gibson, and I'm a staff attorney with DLCV in the Institutional Rights Unit. Joining me today is resident expert and senior staff attorney Dana Trainham.
Hi, folks. I'm going to be talking to you later, but I do want to let you know that in addition to being National Healthcare Decisions Day, today is also National Wear Your Pajamas to Work Day. And for that reason, we're only going to show you the slides, and we're not going to do live video. You're welcome.
Just a couple of housekeeping items. Because we have a lot to cover in 90 minutes, we've muted everyone's lines. We're going to ask participants to add questions to the chat or email us directly after the webinar. And we'll get those questions compiled in responses and send them out to the participants. We're also going to be recording today's webinar, and we should have a caption version available online in the next few weeks. So healthcare and other kinds of decision-making come into play frequently in our disability rights practice and likely in your own programs. Today, we'll be looking more closely at healthcare decision-making for older adults, but I think you'll find the information is relevant to other individuals who may be served by your program. And we'd like to say Happy National Healthcare Decisions Day. So National Healthcare Decisions Day is celebrated annually on April 16th, and National Healthcare Decisions Day began in Virginia, actually, in 2006 as Virginia Advanced Directives Day, and became nationally recognized in 2008. The goal of National Healthcare Decisions Day is to get information on healthcare planning out to individuals and professional communities. At DLCV, we also believe in planning for healthcare needs. Healthcare planning is one way people with disabilities can exercise their right to make their own healthcare decisions. We also find that key dimensions of healthcare planning involve supported decision-making principles. So our effort today is to discuss models of decision-making, how advanced directives can help individuals plan for future needs, and how the principles of supported decision-making can help us support individuals' rights to direct and participate in their own care. Older adults may be well positioned to plan for future healthcare needs, but the consequences of cognitive decline and, to a great extent, the perception of cognitive decline place older adults at risk of losing their decision-making authority and independence. We want to give you tools to help your clients retain their decision-making authority and independence to the greatest possible extent. More specifically, we have 5 objectives for the webinar, and at the end of the webinar, you'll receive a feedback survey by email, and you can use that survey to evaluate how well the webinar meets the objectives. The first is understand the landscape of healthcare decision-making for older adults. We also want to understand the principles associated with decision-making capacity, including underlying legal and ethical principles, elements of capacity, and addressing some myths. We also want to understand the basics of advanced directives, what they involve, how they're executed, and self-help resources for you and your clients. We also want to understand the principles of supported decision-making and how to apply them, what it looks like, what it involves, and how to opt in, including resources from the American Bar Association, the National Resource Center for Supported Decision-Making, etc. So let's start by taking a look at the landscape of health. The dimensions of a person's life are impacted by aging. Of course, you're going to see an impact. And so we'll talk about what some recent studies can tell us. I know that a study published in 2014 found that within 48 hours of hospitalization, 47% of older adults required decision help from surrogates. Studies also suggest that individuals' understanding of aging-associated risks to their healthcare needs and decision-making are high, but are incongruent with engagement in healthcare planning. And essentially, older adults understand how certain life events place them at risk for losing independence, but things like uncertainty over the future, feeling like they're too healthy or too sick to plan, not getting buy-in from family and supporters, denial, procrastination, feeling overwhelmed by choices or feeling like there's a lack of options, financial concerns, and personal pride all impact an individual's choice to engage in advanced healthcare planning. But the evidence also shows that discussions about the goals of care are really beneficial for individuals. Individuals who engage in advanced care planning are more likely to receive care that's consistent with their wishes, and the proxies, or the individuals who are helping them make decisions, are more likely to accept the individual's condition and make decisions that are consistent with their wishes. Studies also suggest that when older adults are experiencing cognitive decline, that they're less likely to engage in healthcare planning. And so we want to talk a little bit about decision-making models. And I think a helpful way to organize them is really from the least restrictive to the most restrictive. Now, in the context of guardianship, least restrictive is actually a legal term of art. But I think it's a framework that's helpful for looking at healthcare decision-making generally. So the more input and authority the individual is afforded in the decision-making model, the less restrictive it is. And I've really placed independent decision-making first and supported decision-making after. But again, I just want to emphasize that we expect support to be part of independent decision-making, and that when we're using supported decision-making strategies, the individual is the final decision-maker. Now, power of attorney allows the individual to appoint a surrogate decision-maker, and they get to decide what authority they're delegating to the surrogate decision-maker. So power of attorney is really customizable, and it can cover additional things like financial activities. But if you're just looking at healthcare, you can make an advance directive through the Healthcare Decisions Act. And what the HCDA allows you to do is create a, quote, springing document that goes into effect when the individual lacks capacity and becomes dormant when the individual recovers capacity. That's really what's meant by springing. And so in a valid advance directive, the individual determines who will be their agent and what directives, refusals, and preferences will be in the document. Now, I talk a little bit about proprietary legal frameworks just to say that, for example, in the Department of Behavioral Health and Developmental Services system, an individual can have an authorized representative. And in other parts of the law, there are guidelines for appointing an emergency medical proxy. So in general, if you have an agent, an attorney, in fact, or a guardian, the law prioritizes that person's appointment within those frameworks. But what they really do is provide a system by which a surrogate can be appointed if there is no agent, attorney, in fact, or guardian. And so again, the value of using this process is that you are making the decision rather than basically going to what's the statutory default. And then, of course, guardianship. Guardianship requires a formal finding of legal incompetence from a court. Usually an incapacitated person is considered to be a candidate for guardianship when they're becoming legal adults and parents have concerns about making sure they still have the authority to act on behalf of their adult child. If someone's having difficulty maintaining decision-making capacity due to an illness or condition, or if they're showing signs of long-term cognitive decline. Guardianship is considered highly restrictive, well, for one reason, because it's very costly and difficult to reverse. If an individual develops or recovers capacity, you have to hire an attorney, file a petition, go to court, pay for experts. And it removes an individual's legal identity. In a plenary guardianship, the individual loses the right to make residential and healthcare decisions, the right to marry, contract on their own behalf, vote, and get a driver's license. It can also burden their associational decisions or other everyday decisions, and in many regards, it's considered the death of legal personhood. Now, underlying these models of decision-making are some important principles to consider. We always start with the presumption of capacity. And we'll talk a little bit more in our next section, which is really devoted to discussing what capacity is. But for now, we'll just say that the presumption of capacity is the principle that every adult person is presumed to have capacity to make choices and act on their own behalf, of course, until they're determined to lack capacity in one or domains in a manner consistent with the law and standards of practice. Another important concept is dignity of risk. And that's basically the principle that an individual can make decisions that we find inappropriate, objectionable, or unnecessarily risky. Decision-making authority includes the authority to make bad decisions. But if an individual can otherwise engage in that decision-making process, they're afforded dignity of risk. And finally, the doctrine of substitute judgment. And this is basically the principle by which a surrogate decision maker, to the extent possible, attempts to arrive at the decision that the individual would have arrived at if they had the capacity to make the decision. And so knowledge of an individual's values, preferences, and religious beliefs really help inform those choices and actions of the surrogate decision maker. So next question is, what do we know about the utilization of different models? Well, just broadly, most of us are engaging in independent and supported decision-making. It's really only when we're planning for future healthcare needs or capacity is called into question that we start looking at these other models. And interestingly, there isn't really a lot of reliable statistical data available on the use of advanced directives or power of attorneys and guardianship for older adults, or even generally. The National Center for State Courts Center for Elders in the courts noted a number of difficulties with gathering information on the frequency and types of guardianship. Legal policymaking organizations have advocated for the ability of uniform data on guardianship for many years now, but it's still difficult, and we don't know a lot about how many guardians exist in Virginia, who the wards are, and what's in those guardianship orders. However, we can look to a number of larger trends which may be consistent with our experience in Virginia. The estimated number of adults under partial or total or plenary guardianship in the U.S. has tripled from about 500,000 to 1.5 million people in the last 8 to 10 years. So the demand for guardianship and qualified guardians is increasing, in part due to the aging population. And we generally want to encourage and see encouraged the use of alternatives like advanced care planning for older adults, and that's also becoming more commonplace. But we still struggle with that awareness of aging and long-term cognitive decline and the importance of future planning. And I think it's also interesting to consider how utilization of guardianship is impacted by what studies have termed unfriended adults. Now, I found a study that talked about this term unfriended adults, but basically adults who have decision-making support needs and lack the kind of natural supports that make advanced care planning and supported decision-making appealing alternatives to guardianship. A study published in the American Journal of Hospice and Palliative Medicine in September 2018 found that, quote, the number of unbefriended adults was sizable and likely to grow. And, quote, there have been no studies regarding the quality of medical decision-making and its outcomes for this population. And what I see in my practice is where individuals without supporters, guardianship, however restrictive, may be a more appealing option because in the context of guardianship, we're more comfortable using a professional surrogate or an unfamiliar person. But we really should be committed to using less restrictive alternatives whenever possible. And when we talk more about supported decision-making, we'll talk about natural supports and building natural supports. And we certainly welcome more research on how to use healthcare planning and supported decision-making most effectively with those adults who lack those supports. So what do we know about the effectiveness of various models? Well, research suggests that surrogate decision makers often don't make the decision the person would have made, and it's kind of an imperfect system for replicating the choices the individual would have made. And that isn't through any malfeasance, only that when surrogates are making decisions for another person, they're considering a lot of factors, not just patient preferences, but also well-being. And when they're in a situation where they don't know what the person wanted, they're kind of thinking about, well, what would I want to happen in this situation? What would happen for me? Studies do indicate that where there have been more advanced care planning, there is a higher level of fidelity to the individual's wishes, and that it also makes the individual more confident in the surrogate. It makes the surrogate more confident, and it helps the surrogate or the caregiver feel more confident in the decisions that they're making and better accept the individual's healthcare conditions. And the scientific research really suggests that guardianship actually can promote helplessness and loss of dignity for people, and that sometimes that fear of losing decision-making rights really discourages older adults from planning for care needs. And so we think that if they have a better understanding of the framework for surrogate decision-making, what is less restrictive, what is more restrictive, and what the incentives are for engaging effectively with advanced care planning. I also found it interesting that in addition to cognition, studies show that health and financial literacy really emerged as an independent and primary correlate of healthcare and financial decision-making, meaning that the study suggests really that cognition is only part of the decision-making picture, that education and involvement in decision-making is necessary to do it effectively. Okay, well, having talked about the models of decision-making, I'm going to hand it over to Dana to talk with you a little bit more about capacity.
So, thanks, Melissa. So I'm going to talk a little bit about capacity and decision-making to folks who are on that, and talk about why capacity is integral to healthcare decision-making. So what is capacity? Basically, it's the ability to engage in the process of making and communicating decisions. Pretty simple definition, but it's anything but simple when you get into the weeds of the process. So basically, it involves the ability to understand information that's given to you and make a decision using that information and then communicating the decision that you've made. The things that are important to remember there is that when you're talking about taking in information, you need to consider, how does that individual that you're working with, how does this individual take in information? Because it doesn't do any good to give the information in a way that the individual can't take it in and process it. For example, if someone's going to give me, obviously, I'm not going to understand it. So we need to look at, how is the person going to take in the information so they can best understand it and make a decision for themselves. For some folks, that's going to be visual, for some verbal, for some both. So looking at, how does the individual need to take in information? And then what's their process for using that information to make a decision? Some people have different processes for making the decision after they have the information before them. They may need time. They may need time to process it. They may need time to talk about it. They may need time to research. And then finally, communicate. It doesn't necessarily mean verbally. Some of the folks that we work with do not communicate verbally. They communicate in other ways. And so we need to look at, how do they communicate the decision that they've made.
I think we're just having a little bit of a shaky internet connection, but Dana's going to take it away.
Yes, I am. All right, I'm not sure where we dropped off. So,
informed consent.
So as we talked about before in the previous slide, capacity is subjective, but it's also flexible. It changes, and different decisions require different levels of understanding and thus different levels of capacity. Where the risk of treatment is particularly high, the law mandates informed consent. And where you need informed consent because the risk of treatment is particularly high, then of course the level of capacity is higher. If an individual lacks capacity or needs support, a surrogate who exercises substituted judgment, as Melissa talked about, doing what we think that person would do if they could, can help them get the appropriate treatment consistent with their own values and preferences. Let's talk a little bit about some myths that we hear in our work here at DLCV about capacity. Decision-making capacity can only be determined by a court. That's wrong. Decision-making capacity can actually be determined in a couple of different ways. It can be done by a medical professional and seconded by another medical professional right in the moment when a decision needs to be made. And then secondly, it can be done by a court in the situation of a guardianship proceeding, when a person is found incapacitated by the court and a guardian is appointed. But remember, there is that clinical way of doing it when a decision needs to be made without having to go through the court process. If someone acts against their doctor's wishes or does something that the doctor thinks is not in their best interest, it automatically means they must lack capacity. This is also a myth. Acting against medical advice or doing something that your doctor thinks is not necessarily the best decision doesn't mean that you lack capacity, although it may often lead to a capacity evaluation if the doctor thinks that you're not making the decision rationally. Another thing is that we don't even need to look at capacity unless the patient does not go along with what the doctor is saying. I remember when I first came to work at what was then DRVD, the Department for Rights of Virginians with Disabilities, back in the old days, we actually had a facility that had this as policy, that a capacity determination did not have to be done for any patient until they disagreed with their doctor. Actually, a capacity is a routine part of medical care. It should be happening on an ongoing basis, and it always ensures that an individual understands their healthcare needs and is giving a knowing consent to treatment. Even if they're agreeing with their doctor, they need to know why they're agreeing with their doctor and what they're agreeing to. Cognitive impairment means that a person does not have capacity. This is obviously not true. An individual with a cognitive impairment or someone who is experiencing a cognitive decline, maybe because of older age, may still have capacity to make their own decisions. If someone loses the right to make, loses the capacity to make decisions, it's permanent. That's a myth. An individual may recover decision-making capacity. They may develop capacity with practice and support. I think the greatest myth regarding capacity is that it's static. Particularly with older adults, there's a feeling that when they start showing early signs of capacity deficits, that's the beginning of a long-term decline, and it's a one-way street. That's not true, and those of you who work with the elderly know that's not true. We'll discuss going forward, an important part of supported decision-making is encouraging an individual to use the capacity that they do have. So instead of emphasizing a decline, we're meeting them where they are, and we're encouraging them to keep their decision-making skills spry by using them to the greatest extent that they can. Some other myths, that a person lacks capacity if they can't make a decision, but then we find out that they haven't been given the information to make the decision. So if a doctor tells me I have diagnosis A, and because of that diagnosis, I have choices 1, 2, and 3, but then doesn't explain that to me, and I can't make a decision, then that doesn't mean I lack capacity. It means I lack information. So capacity must be ascertained in the context of treatment and the physician's obligation to give the individual information, and information that helps them understand the treatment and the risks and benefits. Anybody with a psychiatric disorder lacks decision-making capacity, and similarly, anybody who's institutionalized lacks decision-making capacity. These are both false. No diagnosis renders a person incapacitated simply because of the diagnosis, whether that be a psychiatric condition or cognitive disability or cognitive decline. Being in an institution and needing institutional care, whether it's temporary or permanent, whether it's voluntary or involuntary, does not have anything to do with capacity or incapacity. An individual may be involuntarily committed and still have capacity to make their own decisions. And finally, the last myth is that only psychiatrists and psychologists can assess decision-making capacity. This is false. It is true for the purposes of guardianship or an advanced directive. You do need a medical professional to do that. They're constantly evaluating whether the person they're talking to and whether the person who is in a situation where a decision needs to be made, does that person have capacity? That's an ongoing thing with any sort of client-professional relationship that anybody has. So when do we ask the capacity question? And this is really important because I think this is where we sometimes fail. When we discussed the landscape of decision-making, we talked about why older adults and supporters may delay the conversations about capacity and support needs. We talked about how people don't want to have this conversation, and they come up with 101 reasons why today is not the day. So unfortunately, we may not be talking about capacity until incapacity is quite serious. And by that time, it may be quite difficult, inappropriate, or impossible for the individual to really execute a comprehensive advanced directive or do any other advanced care planning. So we should be thinking about this well before capacity is called into question. So when are we asking the capacity question? The short answer is now. How are we asking the capacity question? So medical professionals, and unfortunately I will also include attorneys in this, often seek capacity in a very binary way. Either you have it or you don't. Either you can make decisions independently or you can't, and you need somebody to do it for you. So when a person seems to be losing capacity, the first question may be, how do we get a surrogate or guardian involved? But that really shouldn't be the first question. Like we've said, no matter where we are in the planning or evaluation, we start with the presumption of capacity. We're going to talk a lot more about supported decision-making later in the webinar, but for now I think it's good to note excuse me, that supported decision-making emphasizes that decision-making is a skill that involves knowing when to ask for help, how to ask for help, and who to ask for help. And it also means that needing support to make decisions is normal and appropriate. Think about your own life, right? The need for support when we're making decisions in our lives, that's normal. Supported decision-making is really about normalizing this idea that we're all imperfect decision makers. And this quality of incapacity or needing support isn't a justification to deny a person the right to self-determination. What we're trying to achieve through advanced care planning and supported decision-making is a balance between respecting the right to self-determination and accounting for the very real risk that incapacity poses to a person's healthcare needs and well-being. Everyone should be doing it. Yes, on National Healthcare Decision-Making Day, we are going to shamelessly encourage everyone, including you. If you don't have an advance directive or a plan for your own healthcare needs, don't wait. Make a plan, do it today. Look into the resources we're discussing and that we'll be sharing after the webinar. And when you're working with clients, encourage them and their supporters to make a plan. We're going to give you the tools so that you can have that conversation with your clients. But remember that it's important for you to do it also. I'm going to turn it back over to Melissa.
Thanks, Dina. Now we're going to talk about the basics of advance directives. Like I said, an advance directive is a legal document that allows an individual to designate a healthcare agent or provide written instructions regarding their healthcare needs and treatment preferences. An advance directive is a powerful tool for patients and service providers, and it's supported by state law, specifically the Healthcare Decisions Act. So how can advance directives help older adults? Well, I think the first thing it does is it really opens up a dialogue regarding aging-related healthcare needs. In order to complete your advance directive, you have to have a conversation with yourself and hopefully with others about what's important to you, understanding your current medical care needs and what you'd want to happen in the future. And an advance directive can also include end-of-life planning. And so, it can also prompt some conversations about what a person might want in terms of life-sustaining care, whether they're interested in organ donation, and things like that. And then, of course, it really empowers older adults to make their own decisions. They're deciding whether to have an agent, what powers to give the agent, and giving directives to the agent and healthcare providers. So the document really speaks for them when they can't. And then, of course, it provides documentation and legal protection for decisions. And while they aren't perfectly ironclad, advance directives provide protection to the individual's directives, even if a guardian is later appointed. And it really empowers the agent to become involved at critical times, accessing information and advocating for the individual. Who can help make an advance directive? Now, I think whenever you're working with legal documents, the unauthorized practice of law can come up. And if an individual develops an advance directive with the help of an attorney, of course, that isn't UPL. It also isn't UPL if an individual makes their own advance directive using self-help resources and some of the forums available online. However, in other situations, you may need to think about UPL. And we're always kind of worried that could discourage discussion of advance directives and healthcare planning, but we hope by discussing a little bit, we can demystify it. Now, the General Assembly, in an effort to encourage the use of advance directives, added categories of individuals who could assist with the development of advance directives without engaging in the unauthorized practice of law. And essentially that includes anyone who is a healthcare provider or a qualified advanced directive facilitator, and that was added in 2017. And basically it says that the distribution of the form, the providing technical advice, consultation, and assistance is not the unauthorized practice of law when it's done by a healthcare provider, including their authorized agents or employees, or a qualified advanced directive facilitator. It's also important to keep in mind that providing ministerial assistance, including information about advanced directives, encouraging the individual to complete an advanced directive, or helping them talk through their healthcare needs and preferences, that is an unauthorized practice of law. And the Healthcare Decisions Act very helpfully defines what is and isn't ministerial assistance. And basically that means, again, if you're providing someone with the form, you're talking to them about their preferences, how to complete the form, helping them sign it and obtain the necessary signatures, distributing copies of the advanced directive to their healthcare providers and agents. All of that's covered under ministerial assistance and does not get you into trouble with the UPL. Really the only thing that can is if you give someone legal advice or offer them basically an opinion about the legal effect of a particular thing. So if someone says, okay, well, I want this to be the situation, what will happen then later under these specific set of facts? You know, again, if you're not sure, you can contact the Disability Law Center or refer them to an attorney if they have more intricate questions. But for the most part, again, just providing these self-help resources, talking to someone about it, engaging in that conversation and helping them fill out the form is perfectly fine. So making an advanced directive. It's a pretty straightforward process once you've had the conversation about what will be in it. The individual really needs to decide if they want to appoint an agent. We really recommend that they do, who they'd like to appoint, what powers the agent has, and what written directives they want to include in the document. And if you use the form, it's really as simple as the individual completing the form. And then, of course, the document has to be executed. So in order for an advanced directive to be valid, the individual has to sign the advanced directive in front of two witnesses. And then the witnesses then sign the advanced directive, basically attesting that they watched the person sign it. The statute and the available forms really include the necessary attestation language and signature lines so that you don't have to worry about getting it right. And you don't need the document to be notarized. And the most important thing is share with necessary parties, right? The advanced directive is very little use to someone if their agents, supporters, and medical providers don't have it. So one way you can help an individual is by making sure they get their advanced directive into the hands of people who need it. And while it isn't necessary for an advanced directive to be valid, individuals also have the option of entering theirs into a searchable registry. Connect Virginia runs the Virginia Advanced Directive website, and the directory actually has a really helpful FAQ on accessing advanced directive information and how to get yours registered. There's also a wallet card you can get, and basically that allows anyone to carry information about their advanced directive with them on their person at all times. And it really should include the name and contact information for the agent and how to get a copy of the advanced directive. But if you've registered your advanced directive, the wallet card forms will have a little space where you can write that information. There are also versions, I think one of them is at virginiaadvanceddirectives.org that actually can serve as an advanced directive if it's validly executed, and it just allows the person to appoint an agent so they have a say. So what I've done is actually brought up one of the forms here, and it's probably a little difficult to see all the fine print, but I just kind of wanted to go through and get you acquainted with it a little bit. And this form is the Integrated Advanced Directive form. I like to use this one because it actually covers medical, mental health, and end-of-life care, and it actually has some helpful instructions. And I found this one at virginiaadvanceddirectives.org, which actually includes quite a few forms. We also have one on the DLCV website at dlcv.org. And so the first page here just includes the appointment of an agent, so who it is and their contact information. It also allows the individual to appoint a backup agent. So If the agent is unavailable or unable to serve for whatever reason, there's someone else ready to go to assist. Now, page 2 lists the powers that the person can assign to the agent, and the individual can choose which powers to include. It can be something like authorizing admission to an inpatient facility. It can include controlling visitors to a healthcare facility. And if the individual wants to omit specific powers, they can cross that out on the form and just make sure you sign and date those. On the third page of the form, that includes the Ulysses clause and some of the additional attestation requirements for the Ulysses clause. I'm going to go into detail about that a little bit more in a second, but this is where you would see that represented on the form. And then page 4 includes preferences and instructions about healthcare, and you can list your current healthcare conditions, your treatments, and your providers, so that medical professionals know who to call to get records and information about your current treatments. Page 5 includes emergency contacts and medication. And basically, the individual can include emergency contacts in addition to the agent so that the agent is empowered to share information with other supporters and loved ones. We typically advise people, if you're going to appoint an agent, it really should be just one person, because it can be difficult to resolve disputes between multiple agents. But just because you only have one agent doesn't mean that you can't include other family members or other trusted supporters in your healthcare through the advance directive or through signing release authorizations. It also includes your medications, your preferences, and refusals. And the individual can basically give the agent the power to authorize medications that the individual would otherwise refuse if the agent and the physician think it's important. And you'll see a couple of things throughout the advance directive that say, I can give my agent additional power to override my choices in the moment, if I think that when I'm doing this document that I might refuse something that I actually want. It's just important to understand that those are some additional authorities that the individual may choose or can refuse to include in their advance directive. We also have a section in here for mental health crisis intervention, and that may or may not be important to the individual at the time, but it could also be a good opportunity to discuss what would be helpful in the event of a crisis, particularly if there are emerging neuropsychiatric needs. And then 7 continues with the mental health crisis needs and preferences. And then on page 8, there's some space where you can include other health care details, visitation instructions, who you want to be able to come see you if you're hospitalized or like in a facility for any reason, and life management requests. We might not think about some of the details of our life, like, if we had to be in a rehab facility for a few weeks, who would we want to look after our cats? I have 2 at home, and I have a plan for who will look after them if I need to be away for any measure of time. And so it's, again, people might not have thought of these things before, but as they're going through the advance directive form, it can prompt some conversation. And then finally, we've got page 9, which addresses end-of-life care, specifically life-prolonging treatments. So if an individual has strong feelings about whether they want to be kept alive through artificial means for as long as possible, they can make that explicit. If they are not interested in additional life-sustaining care or treatments, or only interested in specific treatments, they can include that in the advance directive. And then finally, page 10, it's got a little section up there for organ and body donation, but most importantly, it has the attestation clause, and it's all there for you. You have the right to revocation, that you're making this voluntarily and you understand what you're doing. You're providing your signature and date. Your witnesses are saying that they've watched you sign and date, and they are printing their names and signing. And then this form also includes some information and advice about getting your advance directive registered with the registry. Just a couple of additional considerations about advance directives. Your agent can't make decisions that conflict with the advance directive, and healthcare providers can't provide treatment that conflicts with an advance directive. And it can also limit what kinds of treatment a court can order. But it can't compel a healthcare provider to take actions that are medically inappropriate, ethically inappropriate, or violate the law. And the Healthcare Decisions Act outlines those exemptions. But an advance directive is still a very powerful tool for making the person's wishes known and making sure they're followed. Now, typically, an advance directive doesn't allow an agent to authorize treatment when an individual objects to the treatment. However, the individual can add the Ulysses clause to their advance directive, which we talked about a few minutes ago. And the name, comes from, you might be familiar with the Homeric story in the Odyssey, where Ulysses orders his men to lash him to the ship's mast so he won't answer the call of the sirens. And he's like, no matter what I say, no matter what I do, keep me tied up so that I don't meet a watery grave. And so if an individual wants to give their agent that authority, to basically authorize the treatment that they think they might later refuse due to their incapacity, they can add this Ulysses clause. And because this is a significant additional power to give your agent, the law requires some additional attestation. And basically, a healthcare provider, it used to be just a doctor or a licensed clinical psychologist, but they made some statutory changes to expand the class of individuals who could basically provide attestation that you have the capacity to basically appreciate that additional authority that you're giving. And because of the legal effect of the Ulysses clause, if someone's not sure, you might want to refer them to an attorney. But certainly you can kind of provide them some information on how the Ulysses clause would work and let them make that decision for themselves. Okay, well, that's everything on advance directives. So we're going to move on to the basics of supported decision making.
Okay, so it's Dana again, and we're going to spend a little bit of time talking about supported decision making. Have you ever heard the phrase, there's nothing new under the sun? Well, supported decision making is touted as this new thing in the disability field, but it's really a move forever and giving it a name and so think of a decision in your life. Maybe it was a medical decision or a new job or moving or getting married or divorced or going back to school or whatever, a major life decision. What are some of the things that you did as you were making that decision, taking in that information in order to make a decision that needed to be made? And some of the things that people have said when I've done this presentation to a live audience have been talk to family members, talk to coworkers, talk to friends, research on the internet, make a list of pros and cons. I personally have friends who don't make a move without posting on Facebook and getting everybody's opinion on it. Maybe talking to a spiritual advisor, praying about it, meditating, whatever it is that you do to make a decision. Well, guess what, folks? That's supported decision making. That is you making a decision using the supports available to you in these various forms to ultimately make the decision. The important thing is you ultimately made that decision, not the people that were providing support to you. You made the decision using the support that was provided to you. And so it's really nothing new. Supported decision making is a model for supporting people with disabilities to make decisions and exercise the capacity that they have. Specific decisions are evaluated by the person with a disability with the help of one or more supporters, but the decision is ultimately made by the person with a disability. Supported decision making is more than just person-centered, it is person-directed. And this isn't just something that DLCV is touting as a really cool thing. There's a human rights dimension to supported decision making. It's supported by the UN Convention on the Rights of Persons with Disabilities. And this convention advances the principle that every adult is entitled to the presumption of capacity, irrespective of disability or diagnosis, and they are entitled to have decision-making supports necessary in order for them to exercise their capacity. So knowing this and having talked about this, it necessarily changes the capacity question from, can the person I'm talking to make the decision that needs to be made, to, I think, more accurately say, can the person make the decision that needs to be made with support? And individuals are entitled to supports that encourage rather than diminish their participation and equality under the law. I know in my practice, and I know talking to Melissa, she's seen this too, we get family members or professionals call and say, I really want to get the person into a program or into a nursing home or into a group home, but we've been told that they have to have a guardian in order for that to happen. And it's important for everyone to know that third-party interest and liability concerns do not provide a valid justification for removing a person's decision-making rights. And not just decision-making rights, but all those rights Melissa mentioned happen when a person's found incapacitated by the court and a guardian is appointed, all the civil rights that they lose. It's true that a court order, such as guardianship or a legal document, such an advance directive, carries a lot of weight. And lawyers in the healthcare industry, understandably, like that certainty in complex healthcare matters, but it isn't a legal justification for terminating an individual's personhood. It's disability discrimination. But supported decision-making is more than just this high-minded human rights idea that we're aspiring to. It's a very practical and straightforward strategy that is a recognized alternative to guardianship. So throughout this webinar, we've talked about the fact that decision-making is a skill. And like any skill, an individual can improve and master it with support and with practice. It's like any other muscle, right? You need to use it or you lose it. And I think that is so often true for older adults. Once that cognitive decline begins and people step in and start making decisions for them, the older adult may just kind of give up and just think that other people are going to make decisions from them from now on, and they've lost that forever. For older adults, regardless of whether they've had a lifelong disability or they're just now acquiring a disability later in life, maybe because of dementia or some sort of cognitive decline, they can experience shame and alarm if they feel they're experiencing this cognitive decline or that people who want to help them are taking away their rights, treating them like a child. So the way forward is to ask the individual, can the individual exercise capacity with support? And I know I've said that many times, but I think that that's one key thing to take away from today's webinar, is to really ask, can the individual exercise capacity with support? If they know or can learn when to ask for help, how to ask for help, and who to ask for help, then the answer is yes. Then they can exercise capacity with support, but they've got to know when to ask for help, how to ask for help, and who to ask for help. Supported decision-making is typically an informal process, but several states do have supported decision-making statutes and recognize supported decision-making agreements. Our closest neighbor that has that is Delaware. They do have a statute that recognizes supported decision-making. Courts have accepted supported decision-making as an alternative to guardianship. In fact, Virginia, there was a court in Newport News that was the first court in the country to recognize supported decision-making as an alternative to guardianship. That was the Jenny Hatch case in Newport News a few years ago, which probably a few of you have heard of. In 2014, the Virginia Department of Health and Human Services commissioned a study on supported decision-making at the request of the General Assembly, and we're going to provide you the link to that report. So in Virginia, it does have some traction, and we're looking forward to seeing where it goes and hopefully that it gains even more traction. Now, there is no statute in Virginia on supported decision-making, and there are actually some risk to legally recognizing it. We want it to be a flexible process. We want it to be a natural support, and we want it to be fit to the individual, not to a statutory scheme. we don't want a legal definition to determine what supported decision-making is and what it's not. It's also important to note that supported decision-making is not an alternative for other things that we're talking about today in advanced care planning. In fact, it's a really good idea for individuals to use supported decision-making in conjunction with advanced directives or other legal documents that we're talking about. So why are we talking about supported decision-making for older adults? For those of you on the phone who do work with older adults, now might be about the time that you're starting to feel skeptical. You're starting to be concerned. Ideas or thoughts may be coming to mind, words such as abuse, neglect, undue influence. You know, how do we make sure that people are protected in the supported decision-making process? But supported decision-making encourages us to balance concerns like that, which are very important. We're not minimizing them in any way, but we need to balance those concerns with respect for the individual. If you remember Melissa talking about dignity of risk, we need to balance the individual's right to make their own decisions with safety concerns. In addition to the human rights and the dignity dimensions of supported decision-making, it has practical benefits. Research shows that individuals who are involved in decision-making retain the ability longer. Makes sense, right? Just like we talked about muscles and using muscles and how you need to use those muscles in order to keep them operational. Same thing is true with decision-making. If people are allowed to make their own decisions as long as possible, they're going to be able to do that for longer. Another important aspect of supported decision-making is relationships. So the relationship with long-term supporters, it's very valuable to the individual. Supporters and people who know the individual well will have better communication with that individual, even when the individual's ability to communicate declines. Communication is so key to decision-making, so that's really important. And supporters typically know what's most important to the individual and want him or her to exercise autonomy, meaning they will be better advocates if and when a surrogate decision maker becomes necessary. When Melissa talked about how substituted judgment and how people who do become surrogate decision makers need to make the decision that the other person would have made if they could. If someone has been a long-term supporter and has a close relationship with the person, they're much more likely to know what the individual would have chosen if they could. So some strategies for supported decision-making. How does it work? First, we have to understand and we have to prioritize that supported decision-making principles need to occur throughout the continuum of capacity. We need to encourage planning for future need and incapacity while respecting the individual's preferred decision-making strategies in the present. While it might be expedient to have a surrogate decision maker involved, consider carefully whether that would support or diminish the individual's ability to exercise the capacity that they still have. Let's face it, sometimes it's just easier to have a surrogate decision maker because having to communicate to the individual in the way that they communicate, giving them the time they need to make the decision, sometimes that takes longer, and wouldn't it just be easier to ask a surrogate decision maker? But that's not the question we should be asking, and that's not the tactic that we hope that anybody's going to take. But we do understand the thinking of that sometimes it just seems easier. Think about how you can provide support in ways that preserve and maximize the exercise of capacity to the greatest extent that the person still has. All of this to say is the best strategy for supported decision-making is to sincerely adopt the paradigm and allow it to guide your work and practice pretty much every day. Flexibility is critical to the effectiveness of supported decision-making. It can be done in many different ways. So we're just going to provide you a few examples to show you supported decision-making and how it might work in the real world. Supported decision-making through natural supports. That's what you and I do on almost a daily basis. We use our natural supports, including our personal associations and relationships, family, friends, partners, communities, spiritual community, peer community, common interest. We receive the support in this way, and through natural supports, we get help in making decisions. It normalizes interdependence and the reliance on others for decision making. Because remember, we're all imperfect decision makers. There's also supported decision making through peer advocacy. This is very common in the mental health community, for example. It's an extension of the natural supports. It acknowledges that people develop communities with others who have similar lived experiences, including disabilities. Having a community of people who have experience managing a disability and making healthcare decisions are a great resource. They've been there. They can provide insight and inspire confidence with people with similar needs. This can be a support group, a formal peer support relationship, or even an online community. There's also supported decision-making through technology. We are a technological society. A lot of our life occurs online these days. Technology offers many ways to expand individuals' capacity and extend natural supports. We already accept that people with disabilities can benefit from assistive technology to support their functional capacity. And it's no different with managing healthcare needs and decision-making. There are communication apps that connect individuals with their supporters even when they can't be physically present, allowing them to accompany individuals to medical appointments remotely and provide reminders and feedback. There are so many apps. We've heard there's an app for that. There's an app to provide reminders, help folks manage their medications, track healthcare information. You name it, there's an app for that. Supported decision-making through person-centered services. Person-centered services make space for supported decision-making by placing the individual's values and preferences at the center of every decision. Evidence shows that the development of a shared expectation of and familiarity with supported decision-making amongst patients, their supporters, and their healthcare providers lead to improved patient outcomes. The idea is that the more accepted and supported decision-making in the healthcare community, the more likely it is to occur as a matter of course, the more normal it becomes. Supported decision-making through agreement. We have said that a few states in the United States do have a statutory format for supported decision-making agreements. Virginia does not have such a law. But even without a law, supported decision-making agreements give the individual an opportunity to make their supported decision-making relationships and preferences explicit. They can sign them. They can list information about who they rely on for support and how they want to receive that support. There are forms available, or the person could just write up what their preferences are. They can provide medical releases for their supporters. They can explain how supported decision-making helps them. And all of this information can be helpful if capacity is ever challenged, signaling to others there is a plan for how this person wants to make important decisions. And getting to a more formal type of supported decision-making is a microboard. A microboard is a committee or an organization. It's often incorporated with bylaws and charters, and it provides a structure for helping an individual make decisions that their needs are met. This can be used for supported decision-making. So how should we do it? We've talked extensively about how we do it in everyday life, and that's considered a natural way of doing it. We do it automatically. We do it naturally using our personal relationships and networks. But for many of the people we work with, this process doesn't come naturally, and they need help. Remember, for supported decision-making to work, the person needs to know when to ask for help, who to ask for help, and how to ask for help. For those folks we talked about earlier who are unbefriended with no natural support system, we may need to help them develop a more artificial support system to be there when the need arises. I'm going to turn it back over to Melissa.
Okay, so now that we've talked about the sort of overarching principles, we really wanted to break it down a little bit into a healthcare planning and supported decision-making toolkit. And what's in our toolkit? Well, first, we want to have strategies for structuring the dialogue and analyzing decision-making support needs, we want to have some resources for addressing identified support needs. And we think that advanced directives and supported decision-making models are some of our best. And reference materials for your decision-making support library. So we're going to talk a little bit about support needs analysis and some tools that already exist for that. And then we've got some basically linked references. And so when I send you the PowerPoint information, I'll include those linked resources. And those are just really a jumping off point for learning a little bit more and accessing some of the tools you need to implement some of the things that we talked about today. So support needs analysis. I mean, basically the goal of the analysis is to identify like the underlying concern, right? So like I said, when do we ask the capacity question and how do we ask it? At some point we're asking this question and usually it's prompted by some kind of underlying concern. And and again, that underlying concern could just be, hey, something could happen and it's a good idea to plan for the future. Or, this person routinely needs some extra help to get where they need to be and to make decisions confidently and safely. But basically, you're identifying the underlying concern, you're evaluating the sufficiency of the existing supports and services, because sometimes the question isn't asked because there's an underlying concern, but there might be concern with the quality of the existing supports, identifying new and additional supports and getting those supports in place. And so I want to talk briefly about a few existing frameworks for that. More information, again, on those is provided in the recommended resources and forums list. And one that I really love is the practical tool. As a professional working with individuals and wanting to learn more about supported decision making, and coming from it as an attorney, the practical tool really helped it click for me. And it's a joint effort of the American Bar Association with support from the National Resource Center for Supported Decision Making. And of course, it's copyrighted material, so I wanted to link to it instead of providing it here. But basically, it's designed primarily for lawyers. But the framework really provides an intuitive and straightforward way of structuring the conversation and guiding the conversation that you might have with an individual or with other professionals involved in this person's care and treatment. And it's really adaptable. And basically, you are starting this conversation, and even though guardianship and how to limit guardianship might be at the very end of that conversation, the conversation is structured so that at each question point, there's sort of off-roads and ways of avoiding that through the provision of natural supports, supported decision-making, and in some cases using legal tools like power of attorney and advanced directives. There's also the supported decision-making brainstorming guide. And again, this comes from the National Resource Center for Supported Decision Making. But basically, this guide helps individuals brainstorm the ways that they're currently using supported decision making and think about new ways that supported decision making can help them or other people that they work with make decisions safely and effectively. And like Dana said, a lot of this is just stuff we're already doing, and so we want to pretend it's like a new thing, but really we're just trying to make what's implicit explicit, because when it's explicit, it can provide a lot of the same benefits to a person as a guardianship. It can help them plan for the future, and most importantly, it can help them demonstrate to other people that they have a plan to safely make decisions. And some of the recommended resources and forms, again, I'm going to link to the practical tool and the Virginia State Bar Advanced Directive resource page, which includes some forms. The Virginia State Bar also runs the lawyer referral service, which is a great way of getting a low-cost consultation with an attorney if a client does need a referral for legal services. And again, DLCV.org and our Advocate on Duty line are also resources that are available. Virginia Advanced Directives, that's virginiaadvanceddirectives.org. I think Dana actually features on some of the materials on that website. It's really great, and it was originally designed, kind of with mental health care consumers in mind, but it's really great at breaking down the process of identifying, who should make an advance directive, how is it beneficial, what are your form options, how do you pick the best form, and how do you get everything off the ground?
Melissa, if I can, just on the DLCV webpage, on the supported decision-making webpage, if you're at all concerned about the issue of the unauthorized practice of law and assisting someone in filling out an advance directive, we do have an advance directive and a power of attorney document with line-by-line instructions. And you can certainly provide that to the people that you work with. Providing the form with the line-by-line instructions that we've created is very safe to do. And then the individual can then do it themselves without having someone assist them, and they can call us with questions.
Thanks, Dina. I also included Honoring Choices Virginia, which includes some information about how to access a advanced directive facilitator, or how to become an advanced directive facilitator. The National Institute on Aging, which includes a lot of really valuable information on decision-making that's targeted for older adults, because some of this information is a little bit broader. The DLCV Ask the Expert series, Advanced Directives, in which Dana and I also have starring roles. We did a video series to help explain what advanced directives are, how they can be completed and executed, and what the benefits are for our constituents. And then I've got another page here. I pulled some of the things from the National Resource Center on Supported Decision-Making website, including the brainstorming guides, the model agreements, a link to the study that we had discussed earlier, a really good article about some of the ethical and philosophical underpinnings and practical considerations about supported decision-making. It's called The Right to Make Choices. I also included a link to the United Nations Conventions on the Rights of Persons with Disabilities that talks about legal capacity and supported decision-making. Some resources about person-centered care planning, and specifically person-centered care for people with dementia, and some of the opportunities and challenges posed by that. And the Virginia Micro Board Association, since that is a kind of a niche area, they have some resources to get some more information about that. And again, you can also visit the Disability Law Center's website at dlcv.org. We have a lot of resources, some of the ones that Dana mentioned, the videos, all kinds of things. And this is our contact information if you'd like to get in touch with us. Like I said, if you have questions after the webinar, to as much as possible, we'd like to share any questions and responses with the entire group so they can all have the benefit of that. But you can email us at melissa.gibson@dlcv.org and dana.trainham@dlcv.org. And we also will include a link to that webinar feedback survey for you as well. And it looks like we still have 6 minutes. So I think that would be an appropriate time to take any questions if anyone has them. But otherwise, please feel free to follow up with us later by email.
Well, if we don't have any questions, those of you, if you are typing, we're still here. But if you don't have any questions, I want to thank you all for participating. It's the first time that I'm aware of that we've hosted our own little webinar. So we learned in the process. Thank you all for being patient with our little snafu earlier.
And have a happy Healthcare Decisions Day. We hope we've given you a lot to think about and the resources to get started.